which I forgot, and that announcement is related to the status of your vaccination. As per the government directives, we are planning to start the college offline. But for that, we need some information. Earlier, before the induction program also, we have shared you the Google form. Tomorrow again, we will be sharing that Google form. There you have to mention the details of your vaccination. On the basis of that report only, we will be able to decide whether to continue online or shift to offline, because the number of rules and regulations and guidelines to be followed are too many and the rules are very strict. Those rules we will be letting you know once we complete our statistics, that how many students out of 138 are fully vaccinated, because the most important guideline or rule is only the student who are fully vaccinated. Fully vaccinated means both dose they have taken. Only those students can be allowed to sit for the offline classes. A student who has taken only one dose, maybe reason may be genuine, but still we will not be able to allow that student. Why? Because the guideline says that only fully vaccinated students should be allowed to sit in the class. Every day you are supposed to carry that card, vaccination card, certificate, vaccine certificate, that we will be letting you know. But tomorrow we will be sharing that Google form. Please fill it at the earliest. It should not happen that every time we need to remind you that please fill this form, please fill this form, then again 2 3 4 5 days will take place just to give you reminders for filling the vaccination form. So please fill the Google form immediately. It will hardly take 1 or 2 minutes of yours, so immediately fill it. If suppose in the morning we are sending you the Google form, by afternoon you should be you should complete that procedure. So by evening itself we will have the data ready with us, so that we can decide in a meeting whether to continue with online or go for offline. So these two announcements were there which I need to make. Now we will move on to our session. Implied
Hello, sir.
condition. Yes.
Sir, one query.
Yes, please go ahead.
Yeah, sir, the college will start in hybrid mode, means offline and online both, or only just offline?
We have put all the options open. We are ready for offline only, we are ready for online only, and as you said hybrid, that is combination of both.
Yes.
Online and offline, that is also we are ready. We have installed the video cam also, so that suppose if next week or next to next week, even if the offline lecture starts, those students who are working or who are unable to join us for offline lectures, they can click on the link and uh, they can attend the lectures through online also. So every option is open.
Okay, sir. Thank you. Thank you so much.
Okay. So now we will move on to our session that is unit number 2. So yesterday we had discussed the conditions and warranties, the meaning of condition and the meaning of warranty. In case of breach of condition, what are the options available to the aggrieved party? That also we had discussed yesterday's session. Now we will be talking about the implied warranties in a contract of sale. So yesterday itself we have discussed the difference between condition and warranty. In short, condition means the most important part of the contract. If that part of the contract is broken, then the aggrieved party means the party which has suffered loss. The aggrieved party is having two options. First option, that it can cancel the contract. Second option, it can cancel the contract as well as it can ask for compensation also. That is in case of breach of conditions. Express breach we had discussed, and we had also discussed the breach in terms of implied conditions. Now we will be talking about implied warranties. So warranty is that part of the contract which is not considered as the most important part of the contract. It is an important part, but it is not the most important part. So if a warranty is broken in the contract of sale, at that time, only one option is available to the aggrieved party, and that option is that it can cancel the contract of sale. So first one, implied warranty of quiet possession and implied warranty to disclose dangerous nature of goods. Implied warranty. Implied, the meaning we all are aware of, where it is not expressed through words or it is not in a written form. So implied warranty of quiet possession. Quiet possession. Quiet possession means the possession is not questioned by anyone. Yesterday we had taken an example that if a buyer wants to purchase a mobile and he goes to the mobile shoppy to purchase a mobile, the buyer never asks a question to the seller that, okay, I am ready to purchase a mobile from your shoppy, but you have to prove that all the mobiles which are stocked in your shoppy, in your mobile shoppy, are owned by you. First, you give me the proofs, you give me all the receipts, documents, and then I will purchase the mobile. When I will be sure that yes, you are the real owner of all these mobiles, then I'll be purchasing one of the mobiles. Now, this type of question is never asked by the buyer to the seller, because it is assumed that all the items which are lying in the shop are owned by the shopkeeper, by the seller. No one believes, no buyer will ever believe that the mobiles which he is selling are stolen from some other mobile shop and he is selling those stolen mobiles. Now, this type of belief will not be there in the mind of the buyer when he is going to purchase a mobile. He will always think that all the mobiles which are there in the mobile shoppy are owned by the seller. Now here, quiet possession means, now if the buyer has paid for the mobile, it is assumed that he is the only owner of the mobile in the whole world of that particular piece for which he has paid the price. So buyer has purchased a mobile worth 10,000. He has paid 10,000 to the seller, and when he has paid 10,000 to the seller, automatically the ownership is transferred from the seller to the buyer. Now buyer will be called as the real or current owner of this mobile phone. and that is called as the right of quiet possession. No one can claim the buyer that no, this mobile belongs to me. I am the real owner of this mobile. And if somebody says that instead of buyer, I am the real owner of this mobile, and he proves that he is the real owner of that mobile, that means the mobile was stolen and the seller was selling the stolen mobiles. चोरी के मोबाइल वो बेच रहा था. Now here the seller doesn't have a excuse. He cannot say that the buyer should have first asked me that whether I am the only person to whom he is selling this particular mobile. As he has not asked me that question, I have sold this mobile to more than one person. I have taken 10,000 rupees from Mr. A. I have taken 10,000 rupees from Mr. B. As Mr. B, when he was purchasing this particular mobile, as he has not asked me about these things, I have not shared the detail. So this type of excuse is not available under the warranty, implied warranty of quiet possession. Quiet possession means that the buyer need not expressly ask the seller that this mobile which I am purchasing, can you confirm that I am the only owner of this mobile? This he need not say to the seller because he enjoys quiet possession. पूछने की जरूरत नहीं है. आपने 10,000, बायर ने 10,000 रुपए दे दिए, मोबाइल जैसे ही उसके पास आया मतलब वो ओनर बन गया. उससे पहले एक और बायर आया था, उसने वो मोबाइल पसंद किया, उसने भी सेलर को 10,000 रुपए दिए. उसने सेलर को बोला कि मैं 2 घंटे के लिए बाहर जा रहा हूं, 2 घंटे के बाद आऊंगा और ये मोबाइल लेके जाऊंगा. तो मोबाइल पहले ही बिका हुआ था, फिर भी मोबाइल को बेचने की कोशिश की गई. सेलर जब उसका ओनर था ही नहीं, दूसरा ही ओनर हो चुका था, तो सेलर ने उसे कैसे बेचा? और यहां पर सेलर ये नहीं बोल सकता कि आपने पूछा नहीं बायर को, इसीलिए मैंने आपको भी बेच दिया. तो दिस इज कॉल्ड एज क्वाइट पोजेशन. सो implied warranty of quiet possession means that whatever you are purchasing, even if you are not categorically asking the seller that are you the real owner of this, still it is believed that as the buyer has paid the price of that particular goods or particular product, he immediately becomes the owner of that, and that is called as quiet possession. Next one is implied warranty to disclose dangerous nature of goods. Now,
Sir?
there are certain goods which are dangerous in nature. Yes?
Sir, your PPT is not visible.
Arey, just a moment. Huh? Right from the beginning it is not visible, or now it is not visible?
Sir, from beginning it was not visible.
But I had asked. And somebody said yes. Okay. Is it visible now? Just give me a minute.
Yes, yes, sir.
Yeah. Is it visible now?
Yeah.
Yes, sir,
Ah,
visible.
okay. Okay. Thank you. Thank you. Now, the second one is implied warranty to disclose dangerous nature of goods. So, when a seller is dealing with dangerous nature of goods, it is expected that all the information related to that goods or the important information related to that goods is to be disclosed to the buyer, even if the buyer is not asking for that information. Now, suppose buyer is a farmer and seller is into the sales of pesticides, कीटनाशक जो रहते हैं. अब कुछ कीटनाशक ऐसे रहते हैं जिनके जो केमिकल्स रहते हैं वो डेंजरस होते हैं. वहां पर उस बॉक्स के ऊपर लिखा होता है कि प्रिकॉशनरी मेजर्स टू बी टेकन while opening that particular box, कि आपने प्लास्टिक के ग्लव्स, यू शुड वेयर प्लास्टिक ग्लव्स बिफोर and goggles before opening the lid of that particular box or bottle, because it is harmful, it is dangerous for the skin or for the eyes. Instructions of for use is also written on the box or the bottle. Now it is expected that the seller, if he is dealing with those dangerous products or dangerous goods, which if proper care is not taken can be harmful to the buyers, at that time it is his responsibility, it is implied, it is already understood that he has to share that dangerous information with the buyer. Suppose all the instructions on that pesticide bottle is written in English, everything is written, how dangerous it is, then instructions for use, everything is written, but it is written in English. The farmer who is buyer of that particular bottle of pesticides, now he is unable to read the English. He cannot, he is say illiterate person who is unable to read or write. Now this person who doesn't know the meaning of the words written on the bottle, and if the seller doesn't guide him properly about the dangers associated with that, carefully that bottle is to be handled, if it is not shared with the buyer, and if buyer opens that bottle and some accident happens, at that time the seller will be held responsible and the contract, that is the sale of that pesticides, can be cancelled and he will be forced to pay the entire amount of that bottle to the farmer. Here he cannot get an excuse that as everything was written on the bottle, as the farmer has not asked me and there was too much rush in my shop, because of that rush I could not share the information. चाहे पूछा हो या नहीं पूछा हो, रश है आपकी दुकान में या नहीं है, फार्मर पढ़ा लिखा है या नहीं है, nothing matters. Only thing which matters is that implied means that everyone is aware of, even if the buyer is not asking for a particular information. If you know that if proper care is not taken, then accident can take place with the buyer, because it is dangerous, it is harmful to the skin or the other parts of the body. At that moment, it is always believed that it is implied. It is already understood that this information has to be shared with the employees. So that is the implied warranties in the contract of sale. Now the next one, we will first understand the concept of unpaid seller, and then we will talk about the rights of unpaid seller. Now the concept is very simple. Unpaid seller. What is unpaid seller? Can anyone just share what is unpaid seller? What is unpaid seller? Very simple. Am I audible to all?
Yes.
Yes, sir.
Yes. What is unpaid?
Sir,
It is very simple.
the unpaid seller is the person who has not.
Yes, go ahead, go ahead.
The unpaid seller is the one who has not received the consideration of his goods or services.
Very good. It is correct. Unpaid seller is a person who has not received the consideration of goods from the buyer. Unpaid and seller, two words are there. Seller, we all are aware of. The person who is selling goods is called as seller. Unpaid, he has sold the goods, but he is received to he is yet to receive the amount of that good or price of that particular product. So till the period he receives the price of the goods which he has sold, he will be called as unpaid seller. सेलर है क्योंकि वो वस्तु बेच रहा है, वो सामान, गुड्स, प्रोडक्ट्स, आइटम्स बेच रहा है, चाहे वो दुकान में बैठ के बेचे, किसी मॉल में बैठ के बेचे, या फिर सड़क के किनारे बेचे. He will be called as seller. क्यों? क्योंकि वो कुछ बेच रहा है. अब वो सेलर अनपेड कब है? जब उसने कोई वस्तु बेची है, कोई प्रोडक्ट बेचा है, पर उसे उसके बदले में उसका जो प्राइस मिलना चाहिए वो अभी तक नहीं मिला. तो जब तक वो सेलर को वो प्राइस नहीं मिल जाता, तब तक वो सेलर क्या कहलाएगा? अनपेड सेलर. वेरी सिंपल. So that is the meaning of unpaid seller. Now we will talk about what are the various rights of an unpaid seller. Now basically two rights are there that we are going to discuss. First one is right against the goods, and the second one is rights against the buyer personally. So first we will talk about the rights against the goods. जो गुड्स उसने बेचे हैं, उस गुड्स के अगेंस्ट क्या राइट्स हैं सेलर के, दैट वी आर गोइंग टू डिस्कस. फर्स्ट, वेयर द प्रॉपर्टी इन द गुड्स हैज पास्ड. प्रॉपर्टी इन द गुड्स हैज पास्ड, दैट मीन्स द ओनरशिप हैज पास्ड in the goods. Now the seller is not the owner. Now the buyer is owner of that particular product, because some part of that price has been paid by the buyer, and there is a deal between the seller and the buyer that buyer will pay the entire price within a period of this duration. Duration can be 2 days, 3 days, 1 month, 2 months, 1 year, or it can be more than that. Whatever which has been agreed between the seller and the buyer at the time of making the contract of sale. So first is called as right of lion. Right of lion is called as the legal right to take the possession of the goods from the custody of, say, buyer. That is called as right of lion. The right to take, the legal right to take the possession of a particular product. Now, for example, buyer has approached a bank to avail car loan facility of the bank. He wants to purchase a car which is worth, say, 10 lakh rupees. And for that, he has approached the bank. Bank has sanctioned the car loan of the buyer. Buyer went to the showroom with those sanctioned documents, and he submitted those documents to the dealer of car, and on the verification of the document, the dealer delivered the possession of the car to the buyer. So here the car or the ownership of the car was transferred from the car dealer to the buyer on the condition that the car is taken on loan which is sanctioned by a bank. There is a contract between the bank and the buyer that within a duration, say, of 1 year, 2 year, or 5 years, the buyer will clear the entire loan of the bank. Now here, by the time or till the buyer clears the entire loan of the bank, although the car is in the ownership of the buyer, still there is a right of lion existing with the bank. If the buyer fails to return the loan as promised, then the bank is having a legal authority that it can take the possession of the car of Mr. Buyer. And that is called as the right of lion, which gives legal right for taking the possession of one's goods. Now here we can very easily find out that 5-year period was given to the buyer, and buyer was supposed to pay in the installment of, say, 10,000 rupees or 20,000 rupees, whatever that was settled between the buyer and the seller, buyer and the bank. So if he fails to give the installments, one installment he has missed, two installment he has missed, the bank will send a notice, first notice, then second notice, third maybe the legal notice can be sent by the bank. And still, if he is not paying the installments of car loan, the bank is having a right of lion against the car which has been owned by Mr. Buyer. Here, the bank can take the custody or possession of the car of buyer. It will be with the possession of the bank till the buyer clears the loan amount. जब तक वो लोन अकाउंट नहीं क्लियर करता तब तक बैंक लीगली उस कार को अपनी कस्टडी में रख सकता है अंडर द राइट ऑफ लायर. Next one. Same is the case with, suppose if the buyer has purchased air conditioner, AC he has purchased 2-ton AC, which is of say 1 lakh rupees. Now this was purchased by the buyer on 10 installments of 10,000. First installment he has paid, but after that he has stopped paying the installments. Then automatically seller can exercise his right of liar. उसने एक इंस्टॉलमेंट पे की थी, घर पे उसके एसी लग गया है बायर के, अब बायर के नाम पर बिल भी फट चुका है, बायर ही उसका ओनर है, पर फिर भी राइट ऑफ लायन इज विथ द सेलर टिल द बायर pays the entire installments or entire price of that particular 2-ton AC. So that is called as the right of lion. Now the second one, right of stoppage of goods in the transit. Transit means transportation. Suppose the seller is living in one place and buyer has purchased say a goods or item from say Mumbai where the seller is, and the buyer is from Pune. Now buyer has promised that within 1 hour I will pay you the entire amount of that particular goods. But for before that, you have to make sure that you send those goods through transport company immediately. So the condition is, I will pay you the amount after 2 hours or after 1 hour, but I am ready to do the contract. I'm ready to pay you first installment or some token amount if you promise me that you will immediately send that particular item through transport at my address in Pune. So his item which he has purchased, buyer has purchased, is now in transit, now in transportation. After 1 hour or after 2 hours, as it was promised by the buyer, if the buyer fails to act accordingly, that means fails to pay the amount, then the seller, that is the unpaid seller, is having a right that it can stop the goods in the transit and it can call back the goods again to his place. Next one, right of resale. तो ट्रांजिट में था गुड्स, 1 लाख रुपए की वस्तु थी, बायर ने सेलर को कहा कि आप भेज दीजिए इमीडिएटली, बहुत अर्जेंट है, मैं 1 घंटे में आपको पूरे पैसे उसके चुका देता हूं. तो गुड्स अब ट्रांजिट में है, गुड्स अब ट्रांसपोर्ट कंपनी ने अपनी रिक्शा में, टेम्पो में गुड्स को रवाना कर दिया. 1 घंटे के बाद पेमेंट नहीं होता है, 1.5 घंटे के बाद पेमेंट नहीं होता है, इमीडिएटली सेलर टेम्पो वाले को बोलता है कि रुक जा, जब तक नहीं होता है तब तक आगे नहीं जाना है। बाद में पता चलता है कि वो पेमेंट होने वाला नहीं या कल पे चला गया। अब यहां पर सेलर उस टेम्पो वाले को वापस बुला लेता है। अब उसे वापस बुला लिया, अब वो टेम्पो का जो गुड्स था वो वापस दुकान में आ गया। नाउ ऑल्दो अब बिल फट चुका है, वो ओनर अब यहां पर बायर बन चुका है, पर क्योंकि बायर ने अपना प्रॉमिस तोड़ दिया, हियर द सेलर इफ ही इज अनपेड he gets a right to resell that particular product. अब क्यों रीसेल हम लोग बोल रहे हैं? क्योंकि पहले एक बार ये 1 लाख रुपए की चीज वस्तु बेची जा चुकी है, पर क्योंकि इसका प्राइस सेलर को नहीं मिला, ये वस्तु दोबारा दुकान में आई, दूसरा कोई बायर आएगा, तो सेलर इज हैविंग अ राइट दैट ही कैन रीसेल दैट पर्टिकुलर प्रोडक्ट टू द नेक्स्ट बायर. Why? Because he is unpaid for that particular item. So that is the right of resale. Next one, where the property in the goods has not passed. जहां पर प्रॉपर्टी मतलब ओनरशिप अभी तक पास नहीं हुई. Withholding the delivery of the goods and stoppage in transit. Stoppage in transit we have already discussed. Withholding the delivery of the goods. यहां पर बायर एक एलसीडी टीवी खरीदता है और उसे एड्रेस बता देता है कि इमीडिएटली मेरे घर पे डिलीवर कर दीजिए, मैं अभी एक 10 मिनट में आपको पैसा दे देता हूं, एटीएम से जाके निकाल के लेके आता हूं और आपको दे देता हूं पैसे. तो जब तक वो एटीएम से निकाल के लेकर आएगा, जब तक वो पूरा पैसा नहीं दे देगा, तब तक वो कॉन्ट्रैक्ट ऑफ सेल कंप्लीट नहीं हो रहा. तो यहां पर the seller who is unpaid is having every right that he can withhold the delivery for 10 minutes, 20 minutes, 1 hour till the price is paid or whatever has been mentioned in the contract. कि मुझे एक 10 मिनट दीजिए, मैं अभी बैंक से पैसे निकाल के लाता हूं एटीएम से और आपको दे देता हूं. तो जब तक एटीएम से पैसे नहीं आते तब तक राइट है अनपेड सेलर के पास कि वो डिलीवरी को विथहोल्ड कर सकता है. Stoppage in transit that we have already discussed. Now the next rights against the buyer personally. Buyer के against personally क्या rights है? First one, suit for the price. Next is suit for the damages. Next, repudiation of the contract, and the last one is suit for contract. So first one, suit for price. Yes, anyone who would like to share anything related to suit for? Yes, suit for price. What is suit for price?
Sir, hello.
Yes.
Sir, if the seller not received his consideration for what the product he has sold, so he has a right to file a suit against the buyer or a customer for the particular price of the product.
Very good. So suit for price is, in simple word, we can say that case can be filed in the court of law by the unpaid seller against the buyer for recovering the price of that sold goods. एलसीडी टीवी 20,000 में बेचा था, बायर ने बोला 2 दिन में पैसे देता हूं, और एलसीडी उसके घर पर चला गया है, इंस्टॉल हो गया है, 1 महीना हो गया है, पर बायर पैसे देने के लिए तैयार नहीं। अब यहां पर एक ऑप्शन अवेलेबल क्या है अनपेड सेलर के पास, कि वो एक केस फाइल करे कोर्ट में कि मुझे इतना प्राइस नहीं मिला है इस प्रोडक्ट का जो मैं 1 महीना पहले बेच चुका हूं। वहां पर वो सब डिटेल दे कि 2 दिन की बात हुई थी, अब पूरे 30 दिन हो गए फिर भी मुझे पैसे नहीं। तो इस तरह कोर्ट की हेल्प लेकर वो पैसा बायर से निकलवा सकता है, दैट इज हिज राइट। सेकंड, सूट फॉर डैमेजेस। सूट फॉर डैमेजेस मींस कि एलसीडी टीवी दिया था, 2 दिन में पैसा पूरा दे दूंगा ऐसा बायर ने कहा, पर बायर ने वो पैसा दिया नहीं। जब सेलर ने उससे पैसे की मांग की तो बायर ने कहा मेरे पास अभी पैसा नहीं है, एक काम करो मैं आपको टीवी वापस कर देता हूं, एलसीडी। जब वो वापस दिया टीवी, तो टीवी में 2-3 स्क्रैच थे, टीवी थोड़ा सा डैमेज हो गया था। अब सेलर उसे कहता है कि ये जो भी डैमेज हुआ है वो डैमेज आपको देना पड़ेगा, जो भी इसमें प्रॉब्लम आया वो आपको पे करना पड़ेगा। बायर इनकार कर देता है, तो यहां पर डैमेजेस के लिए केस फाइल किया जा सकता है कोर्ट में, दैट इज द राइट ऑफ अनपेड सेलर। नेक्स्ट वन, रेपुडिएशन ऑफ कॉन्ट्रैक्ट, दैट मींस कैंसलेशन ऑफ कॉन्ट्रैक्ट। जो कॉन्ट्रैक्ट साइन किया गया था वो कॉन्ट्रैक्ट अनपेड सेलर अगर उसे उस आइटम का पैसा नहीं मिला है, प्राइस नहीं मिला है, he is having the right that he can cancel the contract. Last one, suit for contract. Suit for contract means जहां पर सेलर को ये लगता है कि कॉन्ट्रैक्ट अगर कैंसिल करूंगा तो मुझे लॉस होगा, तो वहां पर एक और ऑप्शन अवेलेबल है कि he can file a case in the court of law and request court to force the buyer to honor the contract of sale which was entered between the seller and the buyer. जो भी कॉन्ट्रैक्ट हुआ था वो कॉन्ट्रैक्ट के हिसाब से बायर ने जो भी उसकी रिस्पॉन्सिबिलिटी है उसको परफॉर्म करना चाहिए। ऐसा कब होता है? जब सेलर को ये लगता है कि अगर कैंसिल कर दिया तो मेरा लॉस है, माल वापस ले लिया तो भी मेरा लॉस है। ऐसी हालत में अनपेड सेलर के पास एक जो लास्ट ऑप्शन बचता है वो है सूट फॉर कॉन्ट्रैक्ट, कि मुझे कैंसिल भी नहीं करना, मुझे माल भी वापस नहीं चाहिए, मुझे क्या चाहिए, जो कॉन्ट्रैक्ट हुआ था, जिस कंडीशन पे कॉन्ट्रैक्ट हुआ था वो कंडीशन उसने पूरा करना चाहिए, जो अब वो नहीं कर रहा है। अब सेलर बोलता है वो नहीं मानता है, तो सेलर अगर कोर्ट के में जाता है और कोर्ट अगर फोर्स करता है बायर को कि यू हैव टू ऑनर द कॉन्ट्रैक्ट विच यू हैव साइंड विथ द सेलर, which you have agreed with the seller in case of oral contracts. So that is the right of that is the right given to the unpaid seller against the buyer. Normally this right is exercised in electronic items or those items which are say which what we can say that every now and then or very quickly the price changes. अब एक मोबाइल सपोज आज अगर आप दुकान में जाके देखेंगे कोई पर्टिकुलर मॉडल और पर्टिकुलर कंपनी का मोबाइल शायद वो 10,000 में, अगले हफ्ते अगर आप जाएंगे तो शायद उसका 100 रुपए या 200 रुपए से कम हो सकता है वो मोबाइल। तो इलेक्ट्रॉनिक आइटम ऐसे हैं कि जिसका जो प्राइस, जो कम होने का जो स्पीड है वो काफी तेज। और दूसरा सबसे इंपॉर्टेंट चीज, टीवी बेचा बायर को सेलर ने 2 दिन टीवी अपने घर पे इंस्टॉल किया, पैसे नहीं दे पाया, बायर ने वापस वो टीवी पेटी पैक करके सेलर को दे दिया। अब सेलर के लिए ये टीवी रीसेल है। जो बायर भी अब खरीदने के लिए आएगा वो 10,000 की टीवी का 10,000 नहीं देगा, क्योंकि उसे पता है कि ये बिका हुआ टीवी है, ये सेकेंड हैंड टीवी बेच रहा है। चाहे वो टीवी 2 घंटे के लिए खुला हो, चाहे वो टीवी 4 घंटे के लिए हो, या चाहे वो 2 दिन के लिए हो, अपने आप उसका प्राइस काफी कम हो जाता है। अब यहां पर अगर सेलर को ये डाउट है कि अगर मैं रीसेल करूंगा तो मुझे फायदा नहीं होगा, मुझे लॉस होगा, तो बेस्ट ऑप्शन क्या है? 10,000 में उसने मेरा टीवी खरीदा था, मुझे नहीं पता, अब उसने कहीं से भी लाके मुझे 10,000 देने चाहिए। मेरी बात नहीं मान रहा है तो मैं कोर्ट में जाऊंगा और कोर्ट से ऑर्डर पास करवा के वो 10,000 रुपए उससे वसूल करूंगा, एंड दैट इज कॉल्ड एज सूट फॉर कॉन्ट्रैक्ट। So this is all related to our unit number 2 about the contract of sale of goods 1930. If you have not understood anything, please ask your query, or else in the next session we will move on to our unit number 3 of legal aspects of business. What is the third unit of lab, legal aspects? कौन सा है थर्ड चैप्टर?
The Negotiable Instrument Act.
Very good. Negotiable Instrument Act. Yes. Anyone having any query? Okay, so no query is there. We are still having 5 minutes, so we can discuss about the next unit, that is negotiable instruments. So in negotiable instrument, most of the things which we are going to discuss in unit number 3 are known to you all. You all are aware of what is a check, what are the different types of check, what is a demand draft, what is the period validity of a check, what actions can be taken against the person who dishonors the check. So all these things which we are going to discuss in our unit number 3 are known to you all. So next, in our next session, we will discuss about the negotiable instruments. It will be better if you come prepared for these negotiable instruments.
Hello.
Yes,
Sir,
Anurag.
sorry to interrupt you, sir. I have one question. Related
please
to
go ahead.
our the rights of unpaid seller. Sir, what was that last
Yes.
wala? The suit for contract means what?
Suit for contract means whatever contract was there. Suppose there was an oral contract between the seller and the buyer that please install this particular LCD at my place. I will pay you the amount of the LCD, 10,000, 15,000, 20,000, whatever the price is, within a day or maybe by 2 days. That was the contract. The seller believed in the buyer and he installed the LCD TV at his place. Now, the seller is aware of the fact that if he force the buyer to give his TV back as he has not paid the amount even after 2 days, then also it will be loss for the seller. And if the seller doesn't want to exercise that right, one of the right available is right to contract. That means right to force the buyer to honor the contract. Contract was what? That please install the TV at my place. I will pay you 10,000 rupees within 2 days. And if he is not listening to the request of the seller, buyer, then the seller can take the buyer to the court and he can file a case related to suit for contract. Here he doesn't want to resell the product. He doesn't want to keep lion on that product. He don't want the custody of the product. What he wants is, he wants that whatever terms and conditions which were agreed earlier by the buyer has to be honored by the buyer, and the court should force the buyer to honor those conditions. And what was the condition? That within 2 days I'll pay you 10,000 rupees. You pay 1,000 rupees, that's all. I don't want to get the TV back because it is again difficult to resell the second hand TV. And here the seller is aware that he is going to be at loss. To avoid this loss, instead of exercising his right to resell or right to lion, he is going for right to contract. So that is called as right to contract. Yes, anything else?
Thank you so much, sir.
Okay. Thank you everyone for being present in today's session. In the next session, please be prepared for negotiable instruments. We will start with unit number 3. Thank you.
Thank you, sir.